It is 6:33. Why don't we get underway? Our guest this evening is Tom Hennick from the Freedom of Information Commission, and we are eagerly awaiting any illumination you can shed.
Well, I certainly hope I don't disappoint. Thank you for the invitation. I doing these workshops. I've been here before. This is it's a little bit like Old Home Week. My first job out of college in 19 was covering old Saybrook for the Middletown Press. Town Hall was where the Kate is. When my wife and I go to the Kate, I always get a kick out of saying, well, that's where Barbara Maynard's office was, and that's where Planning and Zoning was. And Charlie Doherty's office was down here. So every time I come down here, it's sort of a kick. This was a school back then, so you've done a great job with this. So I really, that's just the personal note. But we enjoy doing these workshops because it means you're interested in trying to find out a little bit more about freedom of information. We try to make them somewhat informal. I'll be doing a lot of talking, but if you've got a question, or if you've got an issue, say, gee, that's not quite how we do it, or that's not how I quite understood, just stop. Those of you on Zoom, just unmute, fire out the questions. We'll try to answer them, give you the best information we can. Just so you know a little bit about me, and I sort of gave it away before, I'm not an attorney. I'm a former journalist, but I've been doing this, the FOI Commission, for going on 21 years. And the idea is not to beat you up, not to make you miserable, but to try to help, to try to answer any questions you might have about FOI, to give you some tools to work with when it comes to freedom of information, so that if you're faced with a situation, you're in a better position to handle it, and not worried about things relating to FOI as opposed to, the tasks you've been elected or assigned to do on the different boards that you have. That's where your focus should be. But we need to think about freedom of information because it's the law of the state of Connecticut, and it goes hand in hand with being on a board. A lot of times when I do these workshops, especially in the evening, people say, Tom, you don't get it. We're volunteers. We didn't sign up for this FOI stuff. Well, just so you know, I do get it. I was on a board in my town for 10 years. I chaired it for the last 5. I was a member of our Board of Selectmen for a couple of years, filling out an unexpired term, and they pulled me back in a couple months ago. I'm on another board right now. So I do get it. I know what it's like to have your life during the day, and then you gulp down dinner and you run out to a meeting. And you all chose to do this to help your community, and that's where your focus should be. So what we want to do is have freedom of information be just part of the flow, part of what you do on a regular basis, and just to make it easier for you and to sort of increase your comfort level when it comes to FOI. So I mentioned it's the law. It's 47 years old. It was Ella Grasso's brainchild when she ran for governor for the first time. And if you do the math, 47 years ago puts us right smack in the middle of Watergate. And you had a country that was in turmoil, a country that was beside itself, on the verge of a constitutional crisis, primarily because a lot of things were being done clandestinely, secretly, behind closed doors. People didn't know what was going on. Their phrase, government works best if it's transparent. People who attempt to run their own government without knowledge is a recipe for disaster. And that's what was going on, as Watergate was kind of unfolding. And Ella Grasso was in Congress when Watergate really exploded. And she was watching all this go on, and she was contemplating this run for governor at the same time. And she said, if I run for governor and win, one of the first things we're going to do is create some kind of an open government law. We're going to see to it that what's going on here in Washington does not happen in my state. As you know, she ran, she won. And one of the first things she did was put forward this concept of the open government law. And she felt it was very important. And she kept her campaign promise. And then she did something that's kind of interesting. If you've ever dealt with the legislature or the legislative process, you'll get a kick out of this. She said, this is so important to our state. I will see to it that this law is approved unanimously by the legislature. Can you imagine? Can you imagine guaranteeing a unanimous vote on anything, let alone a law like this? Well, incredibly, I'm here to tell you, she guaranteed it. She got it. There was not a single no vote in the House. Not a single no vote in the Senate. This law passed unanimously, which brings us back to kind of why we're here today. It shows you how important it was then, how important it remains today, but it also some insight as to why we have to have these kinds of discussions, because to get to the point where everybody voted yes, can you imagine the negotiation? Can you imagine the arm twisting? Well, I like that concept, but maybe with a little different wording on this. Maybe not in that situation. We shouldn't have an open meeting. And maybe that's a record. You get the idea. So you've got a law that's based on a really simple, easy concept, but it leaves an awful lot open to interpretation. And guess who gets to do that? Those of us who are on the front lines. Sometimes on the fly. Sometimes, gee, should we be in executive session tonight? And, the sweat's pouring down. You have to make those decisions. And to do that, you have to have the tools to work with, the knowledge of what the law says to be able to make those decisions. So that's why conversations like this are good and helpful. The law is called freedom of information, but it's not really about free information. It's about access to two basic things: access to public records, access to public meetings. And I'm going to go over both prongs of that with you folks in general, probably a little heavier on the meetings provisions. But again, if there's something that you're interested in that I don't touch on, please don't hesitate to ask. One of the first things I share with people is, that concept that it is about access and it's not really about free information, although a lot of people think that it is. If you work in a town office or you're sitting in a board, people come in and they fire out questions and they say, under freedom of information, I have a right to know. How did you arrive at that budget figure? Why did you make that personnel decision? Why was there a cruiser in my neighborhood last night? Well, that may be information that you're ultimately entitled to, but nothing requires a public agency to answer questions. A lot of people think that it does. Now, we're all public servants. We're going to do that. We're going to answer questions because we want our constituents to know stuff. But when they invoke freedom of information and say they want to ask a bunch of questions, that's not necessarily what the law is about. And if that's ever been an issue for you, or you've ever had that idea that, wait a minute, do we really have to do that under FOI? Think for a second about working at the Freedom of Information Commission, which is where I work. I spend most of my time during the day answering questions on the phone or answering emails. And now you all have a face, for better or for worse, to put with the voice on the other end of the phone. Don't ever hesitate to call, ask a question. We'll be happy to try to help. But people call and ask me all kinds of stuff all day long because they see freedom of information. They ask me for directions. They ask me how to get tickets to the UConn basketball game. I kid you not. A couple of weeks ago, I just said, let me write them down over the course of a week. Listen to some of these. An attorney, a West Haven attorney, called and wanted me to send him the body cam footage from the motor vehicle accident his client had in Bridgeport. They think that we sit in this giant vault surrounded by every record held by every agency in the state of Connecticut. They call us up, we push a button, out it comes. No, it doesn't work that way. The company Global Zoning in Oklahoma wants me to send them the impact studies for road projects on Main Street in East Hartford. They sent that request 4 times. They think that somehow, because it says freedom of information, boom, out it comes. Guy calls up a couple of weeks ago. He says, I need your help. I said, what's the matter? He says, I need a copy of my naturalization papers. I said, what? Isn't that like a federal thing? He says, yeah. I went to them. They were going to charge me $500. I thought you might have an extra copy. A true story. So you get the idea. We have to sort of guide people to understand that it's not about that so much. It's about access to meetings and records. And by the way, some of that information may be available under FOI, but you've got to do a little bit of the work. You've got to go to the meeting where the issue is being discussed. That's how democracy works. So you go and get the records where the information is contained. So meetings and records. As I said, I'm going to focus on the meetings because most of you are on boards and commissions, and then I'll sort of touch on some of the records provisions and hope that that leaves us in a better frame of mind when we leave. So when we talk about meetings, the definition of a meeting. Meeting means any hearing or other proceeding of a public agency. Any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. The bottom line is, folks, that when you gather to do your work, it's a meeting. Make sure it's properly noticed. Make sure it's open to the public. Make sure there are minutes of that meeting when the meeting is done. What do I mean by proper notice? Anybody in here responsible for preparing agendas? A couple poor, unfortunate souls. Remember that the key with an agenda, this is through the FOI Commission, this is through the courts. is that the public be fairly apprised, that's the word that comes up all the time, as to what's going to happen at that meeting. So you prepare an agenda, you want to be as specific as possible. The agenda needs to be available at least 24 hours in advance. Prepare the agenda, it's available in your office if your board has one, or your building if your board has one, and also in the town clerk's office. That agenda needs to be something that, you know, people can look at and say, gee, oh, do I want to go to that meeting or not? It's kind of that basic. The agenda applies for two different kinds of meetings that the law gives us, you know, the opportunity to use. There's a regular meeting and there's a special meeting. A regular meeting is a meeting that you have for a schedule that you've prepared. You prepare it by the end of January of every year that says we meet on the first and third Tuesday, the second, fourth Wednesday, you know, 7 o'clock town hall, 8 o'clock library, whatever that is, that becomes your regular meeting slot. Special meeting is a meeting that you have when you're not scheduled to meet. A lot of people see that word special and they go, wait a minute, we can't do this. We can't. You can do anything you need to do at a special meeting. The only thing that makes it special is that it's not at your regular time, your regular slot. The difference between the two meetings is pretty simple. We both need that agenda 24 hours in advance. At a regular meeting, should something arise that's not on that agenda, you can make a motion to add it to the agenda. Mr. Chairman, this isn't on the agenda. I want to talk about it tonight. Somebody seconds it. If 2/3 of you vote to do it, you can add it to the agenda. At a special meeting, you cannot add anything to the agenda. So if you're in that special meeting mode, you can only talk about what's on the agenda. So those of you who are preparing agendas, circling back to that for a second, I don't know about you, but when I create an agenda, I cut and paste a lot. Items like other business, old business, new business. It's not the greatest agenda item. It doesn't tell you much. But if you're going to have it on a regular meeting agenda, it's okay. The chairman could say, is there any other business? And you could say, yes, Mr. Chairman, I'd like to vote. But at a special meeting, if you've got that on there and you've got nothing articulated underneath, you might as well take it off, because you can't say, is there any other business? You can only talk about what's specified on that agenda. And that's the difference between the regular and the special. A lot of times people will ask, well, gee, what about public comment? People, you know, start talking about things that aren't on the agenda. You know, I always say you want to give people a little bit of wiggle room, because they've come to your meeting, they're interested in your topic. But if they get off topic, especially at a special meeting, when I say, look, that's not on the agenda, we'll be happy to listen to what you have to say, but we're not going to talk about it. We'll talk about it in another meeting if we put it on the agenda. So again,
Can I interrupt?
yes, yeah. Oh, by the way, I want you to interrupt. I want you to ask questions as we go along. Yeah.
Is what you just said only applicable to what, this is with reference to public comment?
Mhm.
Is that only applicable to the agenda for a special meeting? In other words, my question is, if we have a regular meeting and we have public comment, my thought always was they could talk about anything they wanted to talk about, whether it was on our agenda for that meeting or not.
They can, first of all, understand, we'll get to this a little bit more depth. Public comment, public speaking is not controlled by the FOI Act. How you handle that is entirely up to you. But to answer your question, they can talk about anything they want, but if it's not on your agenda and you want to talk about it, you should vote to add it to the agenda. So in other words, let's suppose somebody brings up, you know, traffic at Ferry Point or something like that. You want to talk about it, and it's not on the agenda. You make a motion to add it, and then you can have the discussion. Yeah. Problem with a special meeting is if it's not on there, you can't vote to add it. So, yeah.
We've been advised that people can only comment on what's on the agenda. So you just said that's not correct.
Well, under freedom of information, it's not. You may have rules in town. You may have bylaws. You may have charter. You know, however you set up, but it's in your hands. You can do it however you, meaning either the board or the town, depending on how you're structured, wants to do it.
Okay, thank you.
And so to that point, Chubb's comment about somebody talking about it, bringing up a subject that's off the agenda. And you mentioned if you wish to discuss it, getting it put on the agenda. Does that mean you should not be getting involved in a back and forth lengthy discussion with some public person during public comment?
Okay. Former board chair, former member of the Board of Selectmen, personal opinion, I would agree that you should not. I find that to be disruptive. But having said that, I've been to hundreds of meetings where it occurred. Again, that's a choice that a board gets to make, that a chairman gets to make. I personally don't like that. I think it sort of disrupts the flow of the meeting, but there's no rule, there's no law in that. That's a, when I say personal, I mean, an in-house decision that you would make. There's a third kind of meeting that I always bring up just to let people know that it exists, but then quickly urge you not to use it if you can at all help it. There's a provision for an emergency meeting. Emergency meeting is an unnoticed meeting. It's a meeting that you have when you have, a true emergency. The problem is that what you and I think might be an emergency doesn't necessarily rise to that level in the eyes of the law. We have holidays in Connecticut, and some of them, town halls are open, some of them are closed. Every year for 21 years, every year for 21 years, the Tuesday after Martin Luther King's birthday, I got a call from somebody somewhere in the state. They'll say, Tom, I've got a problem. What's the problem? It's Tuesday morning. Our meeting is tonight. Our regular meeting is tonight. I always make sure the agenda is in town hall and posted before 24 hours before. I forgot town hall was closed yesterday. So I brought it in this morning. Is that okay? It's not okay. It's not 24 hours. That's just, well, we've got way too much to do tonight. I'm making tonight an emergency meeting. Guys, oops, I forgot. It's not an emergency. In our minds, and think about January. Think about how things are just starting to rev up after the holidays. How you're really trying to get some work done. And, it's budget season, all of that stuff. It feels like an emergency, but the law has set the bar really, really high. You don't want to go down that road unless you have to. I've seen multiple boards get dinged because they felt it was an emergency, but it really wasn't. If you can at all avoid it, wait 24 hours. Notice it as a special meeting and carry on that way. If you ever have an emergency situation, the law says, yes, you can meet and within 72 hours create minutes. The minutes reflect what the emergency was, who was there, and what you did about it. It's a whole, what's the big deal? In the interest of time, I have this sort of lengthy story, but I saw a situation where a town had an emergency meeting, wasn't proper. At that emergency meeting, they fired an employee. The employee was livid anyway. And then he said, wait a minute, it was an improper meeting. So he filed a complaint with the FOI commission. Now, the commission was set up as part of this law to adjudicate situations where people believe they've been denied the rights this law guarantees them. So he brings the complaint to the FOI commission. The commission says, no, you're right. This town acted improperly. We declare null and void everything that happened at that meeting. Now, that's one of the commission's strongest powers, but the commission felt at that time that this was clearly an attempt to take this action secretly, basically, without this guy in attendance. So it wipes out the meeting. But when sort of as a shedding a light on this idea of things being interpretive, if you don't like an FOI commission decision that's made, and again, being candid, there's a couple cases pending out of this town that hearing officers are going to make decisions soon. I'll bet somebody doesn't like one of them on either side, and they could be appealed. You can appeal it all the way to the state Supreme Court, is where I'm going with this. So the town didn't like the decision and took it all the way to the state Supreme Court. And ultimately, the state Supreme Court said, we agree with the FOI commission. That doesn't always happen. That doesn't always happen because, again, there's so much that's open to interpretation, and our interpretations sometimes get flipped. But in this case, the court agreed and also declared null and void what happened at that meeting. If you're at all familiar with the timeline of that process, it's not a couple of days or a couple of weeks. It's almost 5 years later. The Supreme Court says basically the guy was fired at a meeting that didn't happen. And now what's the problem? Pay him. Back pay. He's off the payroll for 5 years. It took them another year and a half to figure out and to sort of settle how much money they owe, all because they didn't wait 24 hours to hold a meeting. That's an extreme example of what can happen. But just sort of file that away and think, let's wait 24 hours and have the meeting, and that's a problem that you don't have to deal with. People sometimes ask, what's an emergency? If how do you figure? The example I'll give you is one that I was involved in. I was on the board in my town. It was the Board of Education. I don't know if you remember about 8 years ago, give or take, we had a winter where it seemed like we got 5 feet of snow every 5 minutes. It just seemed like just kept snowing. And one morning we looked up on the roof and we said, uh-oh, we had a problem. The snow was piled up so high, we couldn't wait 24 hours. We held an emergency meeting, allocated funds to get some professionals up on the roof to get the snow off the roof to avoid a real disaster. Keeping people safe, keeping people out of harm's way. You know, those of you who are on the police commission, you may have situations like that, especially, you know, you're in the eye of the storm sometimes. I remember that from the years that I was down here. You may need to make emergency preparations or, you know, those kinds of things that might qualify as an emergency situation. Your meetings are open to the public. Anybody can attend. You know, you passed out a sheet today. If somebody says in a public setting, someone says, I ain't signing that, technically you can't make them sign. Anybody can attend, they can watch your meetings, they can observe. I mentioned to you that public speaking is not required. Most boards do it. All the ones that I've ever been on do it. But if you choose not to on a given night, or you choose to limit on a given night, you've got a packed house and you've got a lot to do, and you say, look, folks, 2 minutes apiece, that's it. You know, those are things you have a right to do to run an orderly meeting. And to that end, you know, this gets a little dicey, but because there's a deadline here, you know, we'll move over to the idea of these virtual meetings. That, you know, we've got some folks on the screen here today. At the height of the pandemic, the governor issued his executive orders and said we could meet virtually. Those executive orders expired last July. The legislature put a piece in place. What I'm about to tell you, however, right now is scheduled to expire at the end of April. For whatever reason, the legislature gave us the permission to continue virtually, to have the meetings in this format, but said it ends at the end of April, April 30th, 22. Now, they are talking about things. I see this, you know, wonderful equipment you have. It doesn't mean you're going to have to throw it out. I'm fairly confident that they're going to put things in place that will allow us to continue to meet in person, in a hybrid fashion like this, or totally virtually, depending on, you know, what our choices are. But we don't know what form that's going to take yet, because they haven't told us. We would ask, you know, what we think. We've given them ideas. We've told them how well accepted it's been and all that stuff. But until they actually tell us what it's going to be, we don't know. But just to that end, if you're going to have a virtual component to a public meeting, the law says that you have to have notice at least 48 hours in advance that there's going to be that virtual, electronic, remote, however you want to say it, component. That doesn't mean the agenda has to be available 48 hours in advance. It just means you tell the world, including all your board members, that there's going to be a Zoom option for tonight's meeting. Then the notice goes up at least 24 hours, the agenda at least 24 hours in advance, and make sure that that link is on there. The link so that people can have that real-time access. That becomes the key to the whole thing. This law, written before, you know, as it played out before March of 2020, the key is that people can access your meetings. So the same thing would hold, you know, with the live access. If it's a regular meeting, you also need to record the meeting. And the recording needs to be available on your website within 7 days. And you have to have that recording up on the site for at least 45 days.
That's all?
That's it, up on the site, 45 days. Now, there are retention schedules that you want to check with the public records administrators, how long you actually have to keep it. But how long it has to be on the site is 45 days.
So we were told that the state librarians had to dispose of stuff after 6 months, and I'm not able to find that information anywhere on that website.
What the state librarian was linking it to, and this goes back to March of 2020, is a provision that it's primarily used with land use. And land use says 6 months after the meeting minutes are approved, you can dispose of it. So I think that again, they haven't codified it yet either. They're waiting to see what the legislature. That's the advice that they were giving. When this all hit back in March of 2020, there was a lot of, you know, what do we do? How do we do it? And some of that remains today. A lot of people have adapted really well, but that was the advice that they gave. 6 months after the minutes were approved, you can get rid of the report.
You can, but you don't have to.
You don't have to. You never have to. You can keep it forever if you want.
Okay, because Larry, I think, said that they had to dispose of that.
Have to? No,
No,
you're allowed
They're
to.
not.
you're allowed to.
You're
But
allowed
they're
to.
not on the web, they're not on the website, but they're not even on YouTube anymore.
Well, they're
I have a
taking
meeting
the
I searched in
discussion
January.
sideways for a moment.
Yeah,
But yes, so to go ahead and manage the information. The documentation was submitted to go ahead and purge the old versions of the meetings, which we did, according to what was allowed.
right. Which is, you know,
So basically, if you want to keep that information, refer back to it, you need to download it yourself once it's posted.
I have, well, again. you've
I
got-
refer back to meetings all the time because there's always seems to be a conflict of what was said and what wasn't
Yeah,
said.
well, you've got the 45 days posted on the website, then you've got the 6 months where the retention schedule, one is the town puts in the request and the public records administrator says, yes, you can destroy it, and that's perfectly okay.
But we weren't notified of this until they were already, like our last meeting, Joe had a question about a video that I just reviewed in January and now they're gone. Like, I think a little bit of a heads up probably would have been good, but I'm just gonna download them myself from now on.
Yeah,
since
There's,
this seems to be an issue.
there's nothing in our law that would require that.
Okay.
That's an internal thing that you would want to discuss. Be aware of the fact that after 6 months,
It could be gone.
they could be gone.
It could be
Yeah.
done.
Yeah.
And in this particular case, we do have a destruction date, which is April 1st, based upon the form that came back from the state. So all of that information is available. All of the records that are not available on the web are available to the first. If you want to request them, we can get you copies of them.
Okay.
The
Up
only
until-
caveat, and I had this discussion electronically with Bruce Carlson today, is that this is a question for, this is a good time for this question,
Okay,
is that when you take a look, I mean, traditionally, somebody requests some documentation and say, that's a 25-cent DVD, CD, throw it on the CD and mail it to them and say, that's it, you're out of it for $1. The problem we've got now is that some of these meetings are anywhere from 2 to 5 gigabytes long. You know, if you want to put them on a USB stick, you might be able to fit a few meetings on a $15 USB stick. $15 is a little much for us to be paying for everybody who generates that kind of request. And our understanding is that for that type of request, when it gets into that kind of money, that we can bill for the materials that are necessary.
just the materials. That's
Just the
correct.
materials.
Yes.
That's correct. So, for example, I do have a request that I've received for a number of the police commission videos, but it's going to take a 1.5 terabyte external USB drive to get done. Potentially $100 worth of external USB.
My suggestion there would be to make sure that the requester understands the cost beforehand. If they want to narrow the scope, that's fine, but if they understand the cost, get your money up front, because the cost, you can get your money up front if the cost exceeds $10.
Can we request that they supply the material?
You can do that as well. Some towns don't like to do that. They're afraid that there might be a virus or something involved. If you want them to do that, that's perfectly okay too.
Yeah, I would rather have the information on a firewall system and have them provide the media as opposed to try to select it.
Either way.
Yeah.
Either way, whatever works. Absolutely.
I'm sure I'm the least tech savvy person in the room, but can you not just share the videos? Like, does it have to be downloaded onto something?
No, we can't actually just share the
Okay.
videos, but we don't have a file sharing capability that we have out there.
So to bring it back a little bit, you know, these are all questions that have popped up that nobody thought about before. And another one that's come up in the last 2 years is Zoom bombing. Have we had any old Saybrook meetings Zoom bombed? Yeah. It's not pleasant in some situations. They are racial epithets, they are insults of board members. Had a lengthy conversation with Bristol the other day. They had a situation where people just cut in and flash pornography on the screen in the middle of a budget session, you know? Is that what happened here too?
Within the first 2 months, maybe, that we started this, and we changed the technology around that to make sure that didn't happen.
The short thing that I was going to point out is you have a right to run your meetings. You have a right to get your work done in an orderly and, you know, distinguished, I don't know what the right word is, fashion. Giving people access does not give them the right to do that. is where I'm going. Now, if we are meeting in person, there's a provision in the FOI Act that says if somebody's out of hand, you can toss them from the room. And if doing that doesn't calm everybody down, you can clear the room. So the same thing would apply virtually. So you have, you're tech savvy, you're able to shut them down or shut them out. I've had questions, I don't know why in the last couple of weeks, board members have been, there's charter revision in Newtown. Now, who, really? And they were with pornography. And the guy says, here's my problem. I've got the recording, I shut the meeting down, but some of that stuff is on the recording. Do I have to post it? And I said, you know what? Probably technically yes, but why not just put something up there that the recording's not available due to technical difficulties or something like that?
So I would imagine in that type of situation, if you wanted to, you get police videos and things like that, where stuff is obscured all the time.
Yeah.
So you maybe potentially go ahead and put the thing up, blur it out so it's on a bit so you can't see it.
Right. Who knows what their what their level of technology is. I've had it happen to me once, just by the way. Very kind of early in the life of the pandemic. I was at home and I was doing a workshop for a group, we'll call them like citizen activist types, like League of Women Voters. So it wasn't even officials. And I'm talking along, blah, 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 and all of a sudden the screen goes black. I hear this loud kind of dance, sort of loud music. Now, I should say at the same time, my daughter is an international teacher and she could not get to her country last year. So she was teaching her first graders from my dining room, kind of over my shoulder down the stairs. So I'm figuring that the noise is coming from the first grade, right? She yells up the stairs. She says, Dad, what's that noise? I said, uh-oh. And just as she says that, I look and the strippers parade across the screen. So here I am talking about FOI and the strippers. I said, well, let me just say they left very little to the imagination. Fortunately, one of the tech people was able to shut them down and we were able to continue, but that is a humorous Zoom bomb. You may be in a situation where it's not so humorous. Do whatever you have to do to end it, to get rid of it, because you don't have to deal with that.
So if that becomes untenable,
Yeah.
you just close down the meeting. What are your options?
Declare a recess.
You could declare a recess, you could shut them out, you could stop the meeting. There's a provision in the act that allows a board or commission to, they use the word adjourn. I'm sorry, to me, when you say adjourn, the meeting's over. I would rather say continue, but they put the word adjourn in the law, so you could adjourn the meeting to a specific date, place, and time. So let's suppose it's 9 o'clock and these people just won't go away. You declare the meeting adjourned until tomorrow night at 9 o'clock or Friday night. That's another option to do that.
I was earlier today, I was attending a Zoom meeting of how to control obstreperous meetings.
Mhm.
And the very firm suggestion, both from General Counsel of the Connecticut Association of Boards of Education and from the sponsoring group, was you declare a recess, which is what you would do if you had an obstreperous person in a real meeting.
Mhm.
Clear the room, get rid of the problem, and then go back and resume your
Right.
meeting.
Right.
So I would think that a recess rather than adjournment
Right.
would be the answer.
And but sometimes they just throw up your hands and say, we can't continue. Those are just options. Again, you're kind of in the moment, you make the call based on what you think is
In the
best.
police commission, usually we have backup.
That would be understood. Right?
In a simple type vein, if the technology just fails.
Yeah.
And you're in a hybrid meeting and somebody knocks down the phone pole that's carrying the network to the building and we're offline. Now, in that type of situation where the public's been cut off.
Interestingly enough, that section 149 that codified some of this stuff said that you're allowed to continue. I wouldn't. I don't know that I'd be comfortable, but the law says at this point that you're allowed to continue. There are ways that boards and commissions can exclude the public. If I say executive session, all of you have probably know what I'm talking about. But remember, folks, that an executive session is a portion of a publicly noticed open meeting. It's not something that sits on an island by itself. I'll get calls occasionally from boards that'll say, hey, we've got an executive session coming up. It's the only item we have to discuss. Do we have to notice the meeting? And the answer is yes. If it's executive session, even if it's the only item, you must notice it. You must convene in public. You must make a motion to go into executive session for one of the 5 reasons for executive session. Motion, second, go in, discuss for as long as you want, and then you have to come out and vote in public. Even if it's the only to vote to adjourn, you know what I mean? You must, so there's a public component, even if it's the only item on the agenda. 5 reasons for executive session. A personnel matter. First of all, in noticing it, in making your motion, do not just say executive session personnel or executive session personnel matter. The FOI commission and the courts have come down pretty firmly on that. You need more. You don't necessarily have to name the individual. Executive session, discussion of a police officer, discussion of the performance of the inland wetlands, person, administrator. Executive session, discussion of the performance of a public works employee. You get the idea. You don't necessarily have to name the person, but you need just more than personnel. If it is the personnel executive session, remember that the person needs to be given notice in advance. The person needs to be told, we're going to talk about you behind closed doors next week. Unless the person comes forward and says, I don't want it behind closed doors, I demand that you discuss me in public. And if the person says that and sticks to that, you cannot go into executive session. That's the individual's right, the right to demand that it be done in a public forum. Now, what's interesting is they don't have the right to demand to go into the executive session with you, which a lot of people think that it is. No, I don't want it in public, but you're talking about me, I get to go in the room. Not necessarily so. Once the person waives the right to have it in public, whether or not he or she enters the executive session with you is up to you. The board controls who comes in other than board members. The only people who have a legal right to be in an executive session are members of the board. If you want to invite somebody in to give evidence, to give testimony, to use their expertise, I know police commission often brings the chief in, Board of Education often brings the superintendent in because you need them to explain things. You're lay people, you want your administrators in there with you. But in the end, they're there by invitation. They're there because you need them in there to help you deliberate, discuss whatever it is you're going to talk about. Yeah.
I'm gonna send out an agenda this coming Friday for a meeting next Friday of the Senior Housing Board of Directors.
Okay.
And we were going to put in a executive session component because the administrator of senior housing didn't want to be present when we discussed purchasing a new, he calls it a mule, the little jitney type thing that they use to shovel snow off the
Okay.
sidewalks. She said she'd rather not be there when we discuss this. Is that?
That's not really a reason for an executive session.
Okay.
Yeah.
We'll see. I
Maybe
haven't typed it
Maybe
yet.
just ask her to leave the room if she doesn't want to be there.
Okay.
Yeah. Did you put out bids for this, or are you just gonna,
Well,
because
if we put it, since 1/3 of our units are HUD, we would have to put it out to 3 different manufacturers or
the
businesses.
reason I ask is because if you had bids in hand, there might be a way to get to executive session, but what you just described, no, I just have it in public.
Okay,
The executive session for pending claims and pending litigation would be the second one. That's pretty obvious. There's a lawsuit, there's a grievance, there's an FOI complaint. You want to talk about your strategy, your negotiations, how you're going to handle that. The third reason, so personnel, pending claims and pending litigation, is a security matter. Security never used to come up very much. And then Sandy Hook happened in 2012, and it comes up a lot more and more each year, I'm afraid. That's sad to say. I spent 10 years on the Board of Education. We never once talked about we didn't need to, everything was under control. But they want to talk about resource officers, and, again, the police commission could get sucked into that kind of conversation, resource officers in the school, or emergency exit plans, bulletproof glass, all of those things. So you can have those conversations behind closed doors. If you think about it, that makes sense. If you had it public, the off chance that the person who's trying to get in, the person you're trying to get out, keep out, is listening to what you're going to do to protect the kids. So you could have that behind closed doors. Another one that's come up in that sort of category recently is cybersecurity. Towns or boards of education have had their computer systems hacked and shut down, and they wanted to take steps to make sure it didn't happen again. They would have those discussions behind closed doors. Again, the idea being the very people you're trying to keep out could be listening to the discussion you're having as to how you're going to keep them out. So you could pull back and have the discussion behind closed doors.
I have a question.
Yeah.
If somebody from the union is having a second step grievance, like for us, it comes to the police commission as the second step. Can you just meet with the union, or do you have to notice it as a meeting and go into executive session?
A second step grievance, if the police commission is responsible for hearing it, you'd have to notice it as a meeting.
Okay.
Yeah.
Just for future reference.
Yeah.
Okay.
And there's a Supreme Court case out of Waterbury back in the 90s. The evidentiary portion of all grievance hearings is public, and then you can deliberate behind closed doors once you've gathered your evidence. The fourth reason for executive session is a land transaction. I suspect that this went on when you guys built your beautiful new police station. There was discussion as to where to build it, how to build it, land to buy, and all those good things. You wouldn't have to negotiate in public is the short answer to that. You'd be able to have your conversation behind closed doors. You wouldn't have to compromise the town's position by saying, this is how much we're going to give, this is how much we're willing to pay. And then someone would say, we could outbid the town because we know what their price is. And the fifth reason for executive session, I was alluding to with the bids, it's a little broader than the first four. It allows a board or commission to have a conversation about a document or documents that it believes are exempt from disclosure. And there is an exemption in the FOI Act for bids and RFPs until you've actually signed the contract. So if you had put out a bid for what did you call it, the mule, and you were looking at bids for the mules, where you could say, wait a minute, these bid packages are exempt from disclosure right now. We'll go into executive session to talk about them. You put bid package out for your cruisers. I don't know if your commission is responsible for that. All the car dealers come in with their bids, and you could look at them behind closed doors because the bids are exempt. Or let's suppose you need a legal opinion. You ask Mike Cronin for a legal opinion. He gives it to you. You become the client. It's covered by the attorney-client privilege. You're allowed to withhold that document so that you can go into executive session to talk about the legal opinion.
I recall reading somewhere that if you're a public agency, the general rules of privilege don't apply. They only apply if you're within one of the other specific areas of
one of them,
protection.
but the document covered by attorney-client privilege will do that. You're correct, except if it's a written document that's legal advice that you have sought, that gives you the pathway to executive session. So that you can't just say, hey, attorney, we want to talk to you on something that's privileged. You could bring an attorney in for one of the first four, that's correct. But let's suppose it's a different topic and you need legal help. You need, what should we do about this, town attorney? You ask him for something in writing or her for something in writing, and then the document is what gives you that right to go into executive session.
To discuss the document.
Right, correct. Remember, folks, in executive session, do not ever vote. Always come out of executive session to take action. Your minutes need to reflect who voted for what or for whom. You want to make sure that that's clear in the record and that there's no action taken behind closed doors. That's really important. Any questions about executive session? Sometimes there are.
I was also told that nothing has to be an executive session.
That's also correct. Executive session is a right. It's a privilege given to boards. It's a tool, but you're never required to go in. Never under FOI, you're never required to go in. Now, some union contracts require certain things, but if you did something in public in violation of a union contract and they came to us, we'd say, sorry, can't help you. It's a different fight, but it's not an FOI fight. In addition to executive session, the legislature carved out, you may have heard the term, the non-meeting. This is one of those things that leaves me banging my head against the wall because it's very difficult to try to explain. But what the legislature did was said, okay, these things, you may think that these are meetings and you want to call them meetings, that's fine. But for the purposes of freedom of information, they're not meetings. So you gather to do your work. All this stuff I've been telling you got to do in public. Legislature said, that's fine. But for these particular things, they're not meetings. The top of the list is collective bargaining. If you are doing collective bargaining with your unions, your strategy sessions before you go into bargain, those sessions are not meetings under freedom of information. So you're thinking, wait a minute, the whole board's here. We're talking about something that's as important as anything else we do, but it's not a meeting. That's correct. For the purposes of FOI, it's not a meeting. Executive level search committees. Your chief retires, goes to Florida. You want to look for a new chief. You can form an executive level search committee that doesn't have to conform with freedom of information. That one kind of makes sense when you think about it. In a position where you're looking for the superintendent of schools, police chief, things like that. Okay. When you look at that, you want the best possible list of candidates, and you're probably going to get applications from folks who are already employed and don't want their current employers to know that they're looking for a job. So that one makes sense. One that I always get a kick out of is you're allowed to have a chance meeting or a social meeting either planned or intended for the purpose of discussing matters related to official business. Meeting's over, you want to go to Luigi's for dinner or Cuckoo's Nest or something like that. You can do that, but you can't talk about business. What else are you going to talk about? I mean, let's not be naive, folks. Let's be realistic. I'm supposed to sit here and tell you, no, you can't talk about anything related to business. Well, that just doesn't make a lot of sense if you think about it. But what I want to tell you to do is keep it on the surface level, please. Can you believe what he said at that meeting? Can you believe how long that meeting was? We ought to bring this up at the next meeting, but please avoid those deep deliberative conversations that you should be having here at the table. I guarantee you the one time you lose sight of that and have a debate over drinks after a meeting, the wrong person sitting in the next booth and files a complaint that you've had an illegal meeting, and you've got a problem because you probably have. Avoid the deep deliberative conversations offline that you should be having here at the table, and you should probably be okay. To that end, when I read you the definition of meetings, you maybe heard the word whether in person or by means of electronic equipment. Electronic equipment was put in that law in 1975. Oh, he left, but the powerful chairman who gets on the phone and says, you're voting this way, and I need your vote on that. You need to do this for me, and please bring this up, and blah, 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 blah. And it's a packed house because it's a real controversial issue. And the chairman says, okay, we're going to discuss X. Do I have a motion? Do I have a second? All in favor? Next thing you know, it's done. What happened? They had the meeting on the phone before the meeting took place, and you can't do that. You can't do that. You have to conduct your business in public. And today we're talking about a lot more than telephones. We're talking about email and text and Twitter and Facebook and all of those things. I'm not telling you to stop using that stuff. I'm not telling you that you can't because you're on a board. But use it judiciously. Use it to disseminate information. The chairman has something that he wants everybody to know. Send it out. Let everybody look at it. The problem comes where you want to be really careful. He sends something out and says, look, I saw this article. I want you all to see it. I think there's things in here that I like. We can implement them. Look at paragraph 2. And then you write back and say, that's the dumbest thing I've ever heard. I can't believe that. And then you jump in and say, no, I agree with them. And then you start a discussion via email that you should be having here at the table. So no problem sending it to everybody, disseminating the information, but don't start those discussions that you should be having at the meeting. I can't stress that enough. People say, well, what's the big deal there? Who's going to know? Remember, and you'll see this in a second, that when you write those emails, they become by definition public records. And somebody can say, I want to see any and all emails having to do with topic A, and you'd have to produce them. And you produce those emails, and they say, ooh, look what they're thinking. And oh, by the way, look at how many of them are talking about it. That's a meeting. So you've got a complaint that you've had, first of all, whatever strategy you're cooking up is now open, and you may not be ready for that. And second of all, you've got a complaint that you've had an improper meeting. So be just really smart to the extent to which you use those devices to communicate, use them, widely, but don't have the discussions that you should be having at the table. Yes,
Have you ever had the situation of people having meetings at meetings, meaning somebody's texting someone and I mean, that appearance,
yes, and I'll go back to my board. I had one woman, who will shall remain nameless, who would not put her damn phone down during the meeting. It made me crazy. Now, she claimed all she was doing was checking on her kids, making sure they weren't eating up too much ice cream, making sure they were doing their homework. But I said, it looks like you're communicating with somebody. Put the damn phones down during the meeting, folks, because we had a case where somebody saw somebody texting madly during a meeting. The woman filed a complaint. Now, think what you will of this woman. There's some people in her town who don't like her, but she filed a complaint and she was found to be correct. The town was in violation because he wouldn't give him up. Then he gave him up, and it looked like he was talking to somebody on the other side of the table. Yes, that's a problem. You don't want to do that. That's an improper communication. And first of all, the optics of it are terrible. It looks awful, especially if you're broadcasting your meetings or if you've got a room full of people. Put the phones down and do your work in an open fashion.
Trump put that to bed for us, because there was people that were constantly, and it just doesn't look right. You have people that elected you to be
Well,
there
good
and
for
you're
you.
playing on your phone.
Good for you.
So,
You were more successful than I was. I could not get her to stop. and-
Ask nicely.
I would have.
I did. I started asking nicely, but I didn't leave. So anyway. That I agree wholeheartedly. Be concise, make sure the minutes are available in 7 days, and move on. Remember that minutes, regardless of how much recording we do, nothing has changed. The requirement for minutes still exists. Some people have called on that. They said, well, gee, now that we're recording, do we need minutes? Well, as you heard, there's, you can destroy some of these recordings. The minutes are permanent. They don't go away.
I have a question. We had a gentleman who had sent us a correspondence. He wasn't able to attend the meeting, Zoom or in public. In the last meeting, we had wanted to attach it to the minutes, and I think I've talked to you about this before. If it can't be attached to the minutes because it's not supposed to be a word for word of everything, can we read it aloud during public comment?
Again, your call.
Okay,
The advice is that it doesn't have to be. There's no requirement. A lot of times people will send stuff in like that. I demand that it be in the minute. It's not their call. It's your
Okay.
call. Yeah. Well, however you want to handle it is
but I
entirely.
mean,
up
it's
to you.
fine to attach it to the minutes.
What's
Like, we
that?
can request that it be attached to the
If
minutes.
you want it to be, yeah,
Okay, no, one of our commissioners who can't be here had that question.
Yeah.
Okay,
that's entirely up to you. It becomes burdensome as far as the record keeping if you attach a lot of things to minutes. So it's sometimes advisable to say, see file, separate file. If you've got a lot of letters or things that come in, maybe just keep a separate file. So the minutes book has one thing, and then somewhere in the police department or wherever your board is, has a record of correspondence that came in.
Did I understand you to say that the minutes have to be posted within 7 days?
They have to be available in 7 days. There's no requirement that they be posted, although most people do. But it's not, if for some reason they're not on a website in 7 days, you haven't violated anything, just as long as they're available. Any other questions about meetings? I want to talk to you a little bit about records.
I just have one other quick thing. When people come for public comment, do they need to identify themselves with their name and address?
Great question, because you don't have to identify yourselves to attend a meeting. You don't have to identify yourselves. Technically, I can come into a board meeting. Who are you? Not required. But if the board wants an identification, if it wants a name and an address, and that's your rule, then you can ask for it.
Okay.
It's not required under FOI because public speaking is outside of FOI. But if that's the way you want to run your show, and many do, I'm not suggesting that it's an odd idea, but that you could certainly ask for it if you wanted to. Anything else on meetings? Anything else you wanted to ask about?
You announced my retirement. I wanted to do.
Oh, well, you're going to Florida, Chief.
How are you?
Good. How are you?
Just one follow-up question on the vice chairman's question with regard to grievances.
Yes.
So we have been given guidance from Labor Council and Town Council that because, at least for the police department, that the grievance procedure is part of the collective bargaining agreement. And that part of the grievance action could be a negotiation on how to resolve the grievance, that it is a non-meeting.
That it is a,
In that the collective bargaining, you could go that route, except I would argue for the evidentiary portion. I think the evidentiary portion is a meeting that needs to be done in public, but if it then, your deliberations fall into negotiation, because evidentiary, you're just gathering facts, but then I would argue that a yes to the second part. And I don't know that that's ever shaken out. We've had cases on just the grievance hearing being public. I don't know that we've ever gone down that road. Public records. Reach a couple pieces to the definition. Public records or files means any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract, whether such data or information be handwritten, typed, tape recorded, videotaped, printed, photostated, photographed, or recorded by any other method. And then the law says, except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, whether or not such records are required by any law or by any rule or regulation, shall be public records. And every person shall have the right to inspect such records promptly during regular office or business hours, copy such records in accordance with, it gives you the section number, or receive a copy of such records in accordance with the same section. I read it fast, but the bottom line is everything is a public record by definition. So if you create it, if you read it, if you use it, if you study it, if somebody gives it to you, these letters that they send in, it falls under the umbrella of public record. Now, if that, and anybody can get a copy or anybody can look at it. So if it's that easy, why are we continuing the conversation? Because on top of those definitions, we have different exemptions, different exceptions, and different exclusions of things that you either are obligated to withhold, juvenile arrest records, you can't give them out by state statute, or you are allowed to withhold. So you're saying, why read us these definitions to tell us that everything's a public record and then tell us you've got all these different ways to hold them back? Because all too often people who do what we do lose sight of the fact that everything's a public record. And we get very possessive. They're police commission records. You can't have them. They're mine. You can't have them. And you've come here 1,000 times for the, get out. We don't like you anymore. You would think that that wouldn't happen after 47 years, but it happens all the time. So when I give my pitch on records and I go over the top when I do it with staff that deals with folks like your folks on a regular basis, you have to forget who's doing the asking. You have to forget what you think, intuitively might be the case with the record. You have to look at it, okay, this is a public record. I'm going to put on blinders and I'm going to look at the various exemptions and things to see whether or not it's a record I give out or whether or not it's a record I hold back. A lot of times people come to public agencies and they throw it all at the wall. Massive requests, they don't know what they want. Boom, here it all is. And then you're saying, what am I supposed to do with this? Remember that a conversation with the requester, even the difficult requester, is always a really good idea. You would be surprised how often and how well that works. See if you can narrow the scope of the request. It doesn't always work, but even the difficult person will say, maybe I don't need all of that. Maybe we can narrow the scope. Here's what happens. They find out what they need to find out that much more quickly. It's less work for you, and it will cost them less money. Instead of whatever terabytes or gig, whatever, maybe they only need this much, and instead of $100, it's a $20 thing. And oh yeah, or paper copies, which is where this law has the base of its fee structure. It's 50 cents a page. So if somebody asks you for hundreds and hundreds of pages, and you say to them, look, it's going to cost you $200, give it to me up front, because if it exceeds $10, you can get your money up front. They may not want to pay $200, and that might trigger the conversation to narrow the scope of the request. What happens if they don't agree to that? They don't want to talk to you. They're somebody who's very difficult. No, I know that everybody gets along in Old Saybrook. I worked here for 2 years, I know. Well, every once in a while, somebody will come in, it's not so easy to get along with, and they won't back down, they just refuse, right? What are your options as a public agency then? Well, understand that a couple of things. First of all, you don't need to create a record that doesn't exist. You don't need to do research for a requester. A lot of times people will come in, especially police departments, I want this report. Well, we don't have a report. We want a list of this. Well, we don't have a list of this. You never have to create something that doesn't exist. Also remember that the law does not require immediate access. It doesn't require immediate access, it requires prompt access. Now, what does that mean? It's not really well defined. The courts told us that prompt means without undue delay. Wow, right. It's a big help, right? I would like, former newspaper guy, I like a deadline. I'd like somebody to say, you got 2 weeks, you got a month, you got 2 days. You don't have that. But on the other hand, this gives you an opportunity to look at the size of the request, to look at what staffing is, to look at what else is going on. One of the stories I like to tell is, it was over in Bethel. They have a guy who's a frequent, it appears out of nowhere frequently. He lives in Brazil, and then he pops into town hall where he used to live and just starts asking for records. So he went to the Board of Education on opening day of school one time and started asking, for 20-year-old financial records. They're not going to stop and do that. They're worried about getting the kids off the buses. And, they got kids riding around on buses. They don't know where that. So sorry, not immediate. You're going to have to wait till we go, searching through the basement for those 20-year-old financial. You can have them. So it's not immediate, it's prompt. And in that case, prompt was extended because there was other stuff going on. Is the bottom line. When you get a request for records, I don't know how you're structured as to who answers those requests. Always make sure there's a response within 4 business days. Response doesn't necessarily mean to generate the records. It means at the very least an acknowledgement. We've got your records, we got your request, we're looking into it, we'll get you the records whenever you need them as best we can. But if you don't respond in 4 days, the law said you've denied access. And you don't need to go down that road. You want to get that letter out in 4 days and then go about the business of producing any records that aren't exempt in a reasonable amount of time, in prompt fashion.
I have a question about records. So I'm the building official and we have all property files. We get emails from,
Oklahoma.
well, most
Texas.
environmental companies.
Okay.
People looking to buy properties.
Yeah.
Always for a property that is huge, that the file is as big as this table. And they want everything. And they want us to email it.
Okay.
I have a
question.
staff of me and 1 person.
Yeah.
I'm out of the office a lot.
Yep. It's a couple things I'd throw out there in a situation like that. It's not uncommon what you're dealing with. First of all, can you have somebody come in and look at them? Have somebody come in and look at them. They can look at the whole file. We're not holding anything back, and then you can pick out the ones you want to copy. Number 1. Number 2 is if it's in paper, you're never required to scan it in and turn it into an electronic copy. It's 50 cents a page plus postage, and we'll send it to you. And understand that there's only 2 of us and I'm on the road a lot, and it's going to take a long time if we do it that way. Those are the 2
And
tips.
normally we just, we say, we have the files, come in, look at them.
Yeah.
And I literally have filled the table with files.
I
And had people
Okay.
look at it and say, I'm good, and turn around and walk out.
Yeah.
Files.
Yeah. That's a much easier path to go down. Yeah. I thought you were going to go down the road of like that global zoning that keeps asking for records and stuff like that. So, yeah.
So I'm Chris Costa, planning and zoning, so we're used to global zoning.
Mhm.
But the other thing, Tom, is that when we get to that point, sometimes we'll request that they pay us in advance. So we'll estimate, we believe there's 8,000 documents, including 50 large-scale prints, and they see the sticker price of that, and we never hear from them again.
Yeah, we had one, $1,200.
When you do that, I think you're on to what I'm going to say. Always estimate high. You can always give them money back, but if you estimate low, you're not going to get the difference.
I mean, if it's something accurate, they're smaller, we'll say, okay, there's 50 pages.
Yeah, oh,
But we'll
sure.
say At this point, we estimate that there's 5,000 pages at 50 cents a page and 80 large scale prints at $5 a
Yep.
page to produce, and that's the other way to make them disappear. Global zoning.
I spent a lot of time in the building and planning office in Old Saybrook, digging up stories when I was here. I say Bob Kelly, he's like a legend, right?
I've seen that name.
Yeah. So anyway, although I hope that helps a little bit when it comes to that.
I got a question.
Yes,
You said public records are records prepared or retained by a public agency.
right.
I have been advised by town council that as an individual member of the police commission, I am not a public agency. So documents that I possess are not documents possessed by the public agency. So
Yeah, respectfully, I would
get me
disagree.
some guidance here.
Respectfully, I would disagree. You're on a board, you have records. We have numerous cases where, board members have been asked to produce records that they have, and routinely been ordered to release them. So I would argue that that logic is flawed. All right. Yeah, I would argue that that logic is flawed. I think I'd leave it at that.
Okay, so let me play this string out a little
Yeah,
bit
sure.
further. A constituent calls me
Right.
and says, I want you to keep this in mind. And I make a note, because otherwise I forget.
Welcome to the club.
Is that a public record?
It's a public record by definition, but there is an exemption for personal notes. So, I talked about everything's a public record, but some of them you can pull back. That would be one that you could pull back. I
Okay,
would argue that that's a personal note that you wouldn't have to give. The notes that you're taking at the table tonight are personal notes. I would argue that would fall under that exemption. Somebody who's watching this says, I want to see all the notes that these people took at this meeting. I would argue you didn't have to.
okay, here's another one that happens. Somebody writes and says, I don't want you to do anything about this, but I just think you should be aware of it. So, I don't raise it to anybody. It's not going to lead to any action. Is that a public record?
I would argue that it's probably a public records that's transitory. You're probably just gonna, maybe take a note on it and then throw it out. I would also argue that you could make a judgment that it's not necessarily in the conduct of public business because you didn't do anything about it. Remember that it's a record that is related to the conduct of the public's business. So
Right, and if the
there's
person is telling me they don't want me to do anything about it, it seems to me it falls outside that.
There's also an exemption that applies to a certain extent for board members with like constituent services. Somebody calls you up with a personal problem. It's not related to something legislative, some action you're going to take. You could make a case that that's, more of a private communication that you wouldn't have to release. There are different exemptions that would apply.
Is that a statutory exemption?
That's
Or is
that one, that
just
one,
implied.
that's implied through a case with the legislator. And it was sort of bifurcated. If you got something about a piece of legislation, that would be public. But if it's about a problem the individual was having, that would not be public.
So if somebody calls up and asks them to fix a parking ticket, that's not something that you have to see.
Well, that is, then it's his job, and the chief will get on it for that, so. Let me give you one example of how an exemption works, and this is somewhat instructive because it's one that comes up a lot. And when I say one example, we could literally be here for hours talking about the different ins and outs. But there's an exemption in the FOI Act that allows you to withhold something that somebody's personnel files. And when I say that, a lot of people say, wait a minute, personnel files, aren't those, no. Our personnel files, those of us who work in the public sector, are also public records. But to be exempt, the law says that it has to be an invasion of the person's privacy. The standard for that comes to us from a 1993 state Supreme Court case. It's called the Perkins decision. Perkins was a teacher who objected to the release of her attendance records. Went all the way to the state Supreme Court. The Supreme Court said, no, wait a minute. You work in the public sector, your attendance records are public, period, end of story. But to have been an invasion of your privacy, the release of those records would have to have been both highly offensive and not a matter of public concern. Very important, both prongs of the test. So what's supposed to happen is something comes in, somebody wants of police officers' personnel file. The chief looks it over and says, I believe it meets both of those prongs. The chief then goes to the officer and says, we've got a request for your personnel file. I think it's an invasion of your privacy. What do you think? If the officer says, I don't care, give it out, then out it goes. But if the officer agrees, then the file cannot be released until or unless the person making the request files a complaint with the FOI commission. The commission says, sorry, chief, you're wrong. No invasion of privacy. We disagree, release the record. Where people get confused with that one is they think automatically, as soon as there's a request, you're going to be notified. You only notify if you want to give the person the right to object, if you believe it's an invasion of the person's privacy. So if someone asks for yours and it gets released and you see it in the register the next day, you're thinking, how did that happen? They didn't believe that what was in there was an invasion of privacy. They would give it out. Now, they're supposed to give you a heads up once they give it out, but they don't come to you for the right to object. We had a case in Middletown a couple of years ago, involved a police officer and involved the media. Situation where the officer was rumored to be having all kinds of trouble at home. The rumors were rampant. They were running all over town. Finally, they took him off the street. They put him on desk duty. They did an internal affairs investigation. Now, the IA report, like everything else, is a public record. So it's done. The report comes out. They look at it and they say, you know, there's a lot about this guy's home life in here. He's clearly having some troubles on a personal level, but he's doing a great job. So they put him back on the street. Hartford Current makes a request for the IA report, as is its right. PD looks at it, chief looks at it and says, you know, a lot about this guy's home life in there. I think it would be highly offensive to tell the rest of the world about what's going on in this guy's house. And oh, by the way, it's not doesn't have anything to do with his work. We think it meets both prongs of the test. They go to him, he agrees, they don't give it out. The Current, as is its right, files a complaint. The FOI commission takes the records and looks at them in camera, tries to, looks at them behind closed doors, nobody else sees them, and say, it clearly would be highly offensive to tell the rest of the world what's going on in this guy's house. And it's not a matter of public concern because he's doing a great job. That's all anybody needs to know. It meets both prongs. Complaint dismissed. The report was never released. The key is that it meets both prongs. A lot of times when people are asking for those kinds of records, the material is highly offensive because it usually involves disciplinary. It involves somebody being suspended or fired or fined or for doing something wrong. So there's offensive material in there. But that does become, that is a matter of public concern. It doesn't meet that second prong, and you'd have to give it out. But that's sort of a process to see whether or not you give out something in there. There are exemptions for things that have trade secrets in them. A lot of times people will march into a building office or a planning office and say, here are my blueprints, here are my plans, and stamp them trade secrets, confidential, don't give them out. Surprise, once you give them to me, they're a public record. It's my call whether or not there's a trade secret in there, not yours. There's an exemption for records that if released would be a security risk. There's a series of, the chief is familiar with the ones for law enforcement. Records that might compromise an ongoing investigation, records that might reveal investigatory techniques, records that might identify witnesses. Witness statements can be withheld. That's all in there. Those are permissive exemptions. Yes.
You were just talking about plans and stuff. I'm sorry, I'm all building.
No, that's good.
Someone comes in and requests a copy of a house that has been built because they want to build it. Am I allowed to give that to them?
It's a public record, but there was a provision, and I'm sorry, I don't remember when, that you need something from you to get the CO, right?
Mhm.
And once the CO is gotten, the person whose house it is can come in and get the plans and take them out, so they're not in the public forum anymore. And if that hasn't happened, if you still have them, then you'd have to give them out.
Really?
Yeah.
Even though someone else has paid an architect to draw those.
If
plans?
there's a copyright problem, it's the person who's stealing it, not yours.
Gotcha.
Yeah, and that's tricky, but that's how that would be judged at the FOI commission, I believe.
Because that happened on a bigger scale, right, with the flyover GIS data way back in the beginning. DEP did the flyover, and other companies FOI'd the data and got it, and DEP claimed, no, this is ours. we paid for it, and it turned out it was everyone's.
Yeah,
So a lot of businesses got all the free, this is way back in the beginning of
Yeah.
flyover data.
GIS. So, like I said, we could spend hours on the different kinds of records. Does anybody have any questions about any specific records that they wanted to ask about?
Well, on personnel files, what
Yeah.
would be the harm in somebody wanting their own personnel file if they requested it?
There'd be none, except there's, I mean, what invasion of privacy could there be, you know? So,
Depends on what's in there, Renee, right? So if there's something in there that could be offensive to somebody else.
right, assuming that the personnel file is all about the person, then it'd be awfully hard to,
Okay.
yeah.
But I mean, could you redact something and give them
You
the
can always
personnel
redact, yeah,
file? Okay,
sure, absolutely, yeah. Remember that we're talking about everything, doesn't matter where you create it. Especially in the last couple of years, we've all worked a lot at home. Oh, it's on my home computer, it's not a public record, wrong. If you're working on Old Saybrook business, it doesn't matter what device you're using. Again, it falls under that umbrella, it may be an exempt record, but it's a public record. So you always want to think in terms of, do I want to see this on the front page of the Register or the Current or something like that before you send it out?
well, that's part of, we just switched to having town email addresses.
Great
Of course,
idea.
everybody jumps to, oh, you just want everyone to be able to complain to you. Well, no, Jill brought up the very good point that it makes more sense to have that email for all business, like we're getting agenda sent to us, whatever we're getting, if we keep it all in there, then it's not in our personal emails.
Definitely makes sense. Let me sort of close that note and share a story with you to show you. Think before you send. One of our major cities law departments during the sort of the height of the pandemic was looking for a senior legal secretary. And much of the work is being done virtually, Zoom, phones. Nobody's seeing anybody because the town hall, city hall's closed. So during the process, the head of the law department, so it's a big city, there's a law department, it's not just one guy, writes this to a colleague. I would like you soon to reach out on behalf of the law department to thank her for her interest in the position and to inform her that we went in another direction. I feel that you have the most experience in our office handling these types of discussions. Tom pauses for effect. After many years of breaking off relationships with your past girlfriends and flings. Did he really write that? Yes, he did. This email is entitled "Let Her Down Easy, Playboy." You can't make it up. What are you doing? Please, now guys. Let's give him the benefit of the doubt and say he was just trying to be funny, lighten the mood. But you can't do that. You can't do that. That's a public record. It's out all over the place. And you're saying, well, wait a minute. How did anybody see that? This email was sent to the colleague who received it in the middle of a virtual deposition being conducted in sort of a virtual courtroom, and the thing dropped onto the screen in the middle of the deposition. Everybody saw it. Folks, please think before you send. Think about what you're gonna, if you don't want to see it, broadcast all over the place, don't send it. Don't send it. Is there anything that we didn't touch on that you wanted to ask about? I thought of something for you guys in planning and zoning. People come in and ask for copies and they say, I don't want to pay for copies, I want to take pictures. Does that happen to you?
We
Yeah.
let them do it all the time.
All right. If you let them do it, that's fine, but some people don't like to. There's a provision in the FOI Act that allows a requester to use a handheld scanner to take pictures. The agency is allowed to charge $20 when somebody comes in and does that. Now, that doesn't include the phone. We've tried for years, and we're trying again this year to get the legislation to include scanners and phones. So the compromise that we've thrown out there, not enforceable, not in the law, but something that other people have used. And we did this in concert with the town clerks and a lot of different people. And said, yeah, we'll let you use your phone. Give us the $20. And if you want to go down that road, again, not enforceable. Many public agencies have tried it and used it, and it seems to be acceptable. We say, look, here's the provision on the scanner. The problem is that some people come in and they want to take the pictures, and they don't want to pay anything. And if you want to go down that road, that's great. That's more access, but nothing technically requires you to let them take those pictures under the law. So it's up to you how you want
For
to.
us, with it, we're short staffed.
It's easier to do it
It's
that way.
easier to have.
Yeah.
Yeah. it takes up less
Completely
time.
understood. Yep.
Just go do it. when
Yeah,
you're done,
and that's
you
fine.
know.
That's absolutely fine. There's nobody, I'm not telling you that's wrong. The fact that that you do that, just more power to you, just, it's probably an easier way to handle it. So
One last question.
you can ask, oh,
Can you give us your work phone number?
no, that's confidential.
An FOI.
It's 860-566-5682. Now, that's the main number, and I give you that one because I'm on the phone a lot. Some of you will attest, you'll get voicemail, but I will call you back. The days that I'm working at home, it sometimes takes a little longer because I have to retrieve them. I'm not sitting right there, but happy to do that.
So, yeah, I'm sorry, didn't get the last question.
Keep
There's
talking,
one more.
yeah.
So this one relates to draft materials.
Yep.
So, and there's part A and a part B to this.
Yep.
So the first one would be, if there's something that has been completed that will say has been finalized, set of minutes, that somebody went through and created a number of drafts, circulated them, and then finally it goes to publish. If somebody requests the preliminary drafts of the final document, can you reject that request?
There is an exemption for preliminary drafts. The problem is that one person's draft is another person's final copy. You know, if it's the last draft and all you're doing is dotting a few i's and crossing a few t's, draft exemption would probably go away. But if it's extremely preliminary, you'd probably be able to withhold it. You use the multiple, you said, so it really depends on the level.
Yeah, so the first to eight part of that question is if we started out, we had a 0.1, a 0.2, a 0.3, a 0.4 that we had, then we finally went to 1.0, and all of those documents were there. If somebody asked for that document, we could provide the 1.0 and withhold the 0.1, 0.2, 0.3 as being.
Again, it's the draft exemption is one of the hardest ones to pin down. It's always a moving target. So it's a case by case basis, but if it's truly preliminary, I keep coming back to that, then you could probably withhold it.
So
Is that the statutory language,
Yeah,
preliminary?
preliminary draft, yes. The exemptions here, it reads this way. It's 1-210B1, it's the first one. And it says you're allowed to withhold preliminary drafts or notes, provided the public agency has determined the public interest in withholding such documents clearly outweighs the public interest in disclosure. So you'd also have to say, you know what, it's preliminary and we don't think you should have it.
yeah, because if there was something going on where the document was being prepared, then the entire drift of the document changed for some reason, then you might want to not present the original
And
point.
that could be legit. That could be, certainly could be legitimate.
Tom, three quick things.
Yes, yes.
Records retention laws and regulations and freedom of information laws and regulations, two separate.
Separate entities.
separate
And we
things.
talked a little bit about some of that before you came back. And
I was listening.
as it has to do with videos.
Yes.
But yes, a lot of times people, how long, you know, you tell us the emails are public records, how long do we have to keep them? Not my job. You know, I'm being funny, but not my job.
But board members, not your job, but board or commission members that have email documents or other documents, there's a records retention schedule to
They
that.
should be aware of that.
Right.
Correct. Yes.
Second question.
That's why
is,
the idea of having a town email account is such a good idea.
Second question has to do with caucuses. I don't know if you had an opportunity. I heard you talk about the different types of meetings.
Yep.
Did you get into
We
caucus?
did not talk about the caucus. Caucus is in that category of things that I mentioned, things that, gee, that feels like a meeting, but it's not. Because the legislature says it's not. It allows members of the same board and the same party to caucus. But it is only same board, same party. People get hung up on the caucus. Well, let's invite the town chairman in. Or let's invite somebody. It's only same board, same party. And if you do that, you're caucusing properly. That's not a meeting. That's in that category with the collective bargaining and the search committees. That's not a meeting.
And then talk about, because I've seen many of your presentations and they're excellent.
Yeah.
Talk about the balance of the caucus. What can be discussed as opposed to what needs to be discussed at the public meeting?
You can't obviously take action, but let's face it, if you're a majority caucus, you can set things up. It's not, it doesn't look good. The optics are bad, but you know, like a city like Norwalk, I don't know what the exact number is, but it likes 11-member town council and 10 of them are the same party. So their caucuses, they hold them privately and, you know, the meetings are sort of pro forma. You can talk about anything in a caucus, you really can, but you would just want to make sure that if it's something that should be public, you want to do it in public. I would avoid talking about personnel matters in caucus. That could come back to bite you.
Why is that?
Because if you then come out and do something publicly that the person doesn't like, you know, they'll say that there's a due process thing that might come up. I say could come back to bite you. You just want to be real careful, things like that.
I would say it's under the same provision if you're talking about personnel in a caucus. If you're doing it in a public meeting, that public agency member has the right to hold it in public session.
Right.
And so if you're doing it in caucus, you're not allowing that employee that due process right.
You just want to be, you know, again, when unions are involved, contracts are involved, you just want to be careful.
But a caucus can't vote.
Right, but you know, if you're the majority and you set it up in advance,
Oh, Chubb and I sat through that.
yeah. So
Can't
Or
do
the
that.
ones.
you just want to be careful.
And the last thing is, no one here, because no one here is a superintendent, is a public agency. But if you're on a board or commission, you're a member of the public agency.
Correct.
Can I ask a question that I don't even know if this is your territory or
Okay.
not? If somebody needs to bring in for information request and it's denied, and then they go to the appeal process, and that information then needs to be bought, like you said, in camera for them to inspect, what is usually the time frame on that?
As far as,
I mean, can this go like years? Can something go 5 years?
in the good old days, before the pandemic, it's 1 year.
Okay.
It cannot go any more than a year. It's usually 6 months.
Okay.
You know, on average.
Okay.
When the pandemic hit, the governor suspended the requirement, the 1-year requirement. So we've got some old cases from, let's say, March of 2020 to June 1 of 21, I think, that are sort of in the twilight zone,
No, that's understood.
but the max is a year.
Oh.
It usually takes much less than that, but the max is a year.
Thank you.
Any other questions? Anything else? Anybody on the screen have questions? They look very happy. That's because they're home. That's because they're home,
Very
right?
relaxed.
So listen, I always bring parting gifts. This is the Freedom of Information American Express card. Don't leave home without it. It's highlights of the FOI Act. It's great for a wallet, a purse, a desk drawer. It's very small type, but we're a very small agency. That same phone number is on the back. The website is on the back. The address on it is wrong because they just moved us, but you can still find us. 165 Capitol Avenue. I will ask you, you guys can take those and then maybe hold some for the folks who are on the phone, on the screen. Do not ever hesitate to pick up the phone and call if you have a question. I would rather head off a problem before it becomes a problem. I don't want, I know there's some pending cases. That's not the reason I'm here tonight. However those turn out, I don't want you to have any more, is the bottom line. I want you to go forward and be able to concentrate on the work that you've been hired or elected to do and have FOI become like second nature, so.
Tom, thank you
Yes,
very much.
you are welcome. Have a good night, everybody.
Thank you, Tom.
All right, you're welcome.